YouTube, it's Tone back with another one for you. This one is a continuation of dealing with presentments. This is number four, video number four. We're gonna get into this here, talk a little bit about the structure and the rules of the game, and then how the charging instruments are really just presentments. You know what I'm saying? Offers, commercial offers at that. So let's get into this real quick. So further significance of surrender inheres in realizing that we see things far more as we ourselves are rather than what something is in itself. A moment's reflection reveals that anything can be viewed, perceived through, about, and acted upon in an infinite number of possible ways by an infinite number of possible beings. Everyone observes and experiences life from his or her own unique nature and position in space-time. No two perspectives are the same, nor can they be. And that's a thing to keep in mind too, is that it's not possible to ever see things the same way as somebody else. It's just not physically possible. So you can come as close to an agreement as you possibly can, but just know that nobody can ever see something the same exact way that you do, because you are you. So as someone once quipped, when you hear two accounts of the same automobile accidents, it makes you wonder about history. The Bible is full of admonitions against acting in violation of this truth via others, such as "Thou shalt not bear false witness, and judge not, that ye not be judged." So that certainly, after all, does anyone possess after the truth, the whole truth, and nothing but the truth, that mighty justify slandering or judging someone, or might justify slandering or judging someone. And so that's the thing. So truth doesn't even exist. You know what I'm saying? You look in the canons of law, even say that truth isn't even a thing. You know what I'm saying? It's subjective. And so that's why you need to rely on contracts, because that shows a meeting of the minds and leaves out and doesn't leave out any of those details that could possibly become an issue for court proceedings and litigation in the future. So contracts is the way to go. So therefore, surrender really means giving up one's entrenched position in favor of allowing clearer and more holistic understandings to emerge. The ultimate end of this approach is to perceive existence as it is rather than how we might think or believe it is. Two further quotes of Zen masters come to mind: "Do not seek the truth, merely cease to cherish opinions, and if you understand things as such as they are, if you don't understand things as such as they are, the actual truth, and anything is such as it is." Yo, this fucking dude's crazy the way that he writes. So nature of its existence. The more we live in this manner, the more grounded in happiness and integrity our life can become. So basically what it's saying is stop trying to understand and just kind of let things be, because when you try to understand, I think too hard, you're gonna start to try to force things through a filter and idea and concept that you have of it already, usually, right? Rather than going into a situation without any preconceived notions and ideologies attached, because then you're going to be able to have a lot more natural or neutral outlook on it. So in court, why do we lose in court? It is not because it is a military or maritime court, which it is, often evidenced by the gold fringe on the flag. It is not that we are under implied or adhesion contracts at some municipal corporation, if we so raise the issue of contract law. It is not a plethora of other reasons advocated by innumerable patriots, all of which reasons are rabbit trails. So the short answer to why we lose in court is that we lose if, number one, we dishonor any of the people and processes that impinge on us, thereby enjoining the issues described in the presentment, so that we become bound by the matter. We have no right to deny or speak to anyone else's utterances, and doing so lands us in the middle of their novel, pretty much lending credence to any of the bullshit that they're talking about. So we're going to get into traverses here in the bottom, which is public controversy, which is what you want to avoid, because then when you do that, you essentially end up right where they wanted you, and then you need a referee, which is a judge at that point, for the controversy that has arisen. So you don't want to argue with these people. You want to just settle the matter if you can. Number two, we traverse. Traverse is going to be a challenge, right? It's going to be conditional acceptance. It's going to be could be a number of things, but essentially it's pretty much when you're not agreeing and settling the matter. The opposite of that is going to be a traverse. So we I mean, there's a few other options too as well, but that's pretty much it. So we traverse and therefore contractually amalgamate ourselves into the straw man and into the court's jurisdiction, so that we endure in the flesh the results of whatever trial or hearing might occur dealing with our straw man. It is the straw man that appears, is tried and sentenced, not us. By traversing, however, the real us gets to go along for the ride and experience in reality the judgment against the straw man. Number 3, we fail to discharge the charges, and that would be like settling the matter, right? A4V, accepting for value, etc., because it's all really commercial in nature. You understand that now. So thereby authorizing the system to enforce commensurate consequences upon us. And so that's how you end up in an illegal situation that becomes legal because of your complacency and acceptance, silent acquiescence. So that essentially places you into the contract. So 4, we have no according to them. I mean, I fucking think it's bullshit, but it is what it is. So we have no facts and evidence substantiating our position placed by our competent witness on the court record of the case. The crucial matter is discussed below in greater detail. 5, we have not bonded the case. And that's something to keep in mind too, is to find out if the case is even bonded to begin with, and look into how to bond the cases as well too, because if it's not bonded, you could bond it, which means that you become the owner of the case, and then you could just freaking dismiss the case. So, but you're gonna find that a lot of the times these people don't bond it until after you plead guilty and shit, because they don't want to be liable if you were to beat the case. Because if they bond it, then they're promising to pay if they lose. So let us briefly discuss these issues. Number 1, we avoid acting in dishonor by accepting and returning for value whatever presentment or charging instrument we are provided with, and by not arguing, fighting, denying, or ignoring. Well, that was a long first page right there. I have a few more of these. So we do not join the dispute by traversing, by which we leave our own ground and tacitly give reality and credibility to the opponent's claims and allegations that are not facts, but only presumptions and assumptions, until we stipulate expressly or by dishonor. And joining the issues in a presentment, such as denying allegations or charges, or saying that we don't owe an alleged debt, is a dishonor that enjoys us with the court's jurisdiction and our own straw man, and creates a dispute that grants a court subject matter jurisdiction. It sucks up into the man-made game of imaginary disputes between fictitious entities. The definition of traverser in Black Law Dictionary confirms the point succinctly. Traverser, in pleading, one who traverses or denies a prisoner or party indicted, so called from his traversing the indictment. So that's what it is. So you figure you're getting an offer, a commercial offer from a fictitious entity, which is the court. You could look at it as like a Walmart. So it's a fiction. So it's a fictional character. Now imagine if Walmart sent you an invitation to go to one of their sales, and you grabbed it and you started challenging them, and you started getting crazy with their manager and started just fighting with them. Essentially what you're doing is engaging in battle with a fictitious character, and now you're looking pretty fucking ridiculous. So I can see why the judge would want to go ahead and step in at that point, because you obviously don't know what the fuck's going on, so you probably would need some assistance at that point, right? I would imagine. So whenever we, i.e. our strawman, are charged with something, that charge is a bookkeeping entry of liability on the ledger and must be discharged by entering a balancing or offsetting asset. Filling in the asset side usually occurs by the loser parting with the public funds of some kind, such as a check or Federal Reserve notes, or doing community service, or being bonded and incarcerated as the surety. When we discharge the charges by acceptance for value, which is a banker's acceptance, we end the controversy and become the owner of the contract. Each of us is a private banker. Under banking, our acceptance and return for value establishes the facts and makes us owner of the transaction. We then own both sides of the deal, i.e. both the creditor and the debtor side. By accepting from the private side and providing the value from the private, i.e. substance side, we end the dispute and remove the equation from any controversy for a court to resolve. Because that's the only reason why they would ever have to be involved, is if there was a controversy. And this goes with like mortgages and shit like that too. You can conditionally accept their offer and things like that, and challenge it just like any other alleged creditor or collector, and do it in that way. And essentially what you would be doing is that, letting them know that you don't have a problem paying, but you're going to need them to prove that you do have to pay. And so you're going to request forensic auditing and things like that done, accounting and things like that, right? So number 4, it is imperative to understand that the admiralty equity courts of the system do not deal with the reality, substance, and facts and evidence. They deal in assumptions, such as unsupported claims and charges, and presumptions, unexpressed rules by which the system operates, and stipulations, agreements that create the facts. Because they are straw men and cannot be competent witnesses through the sworn testimony, neither attorney nor officials can place actual facts and evidence on the record that a judge can judicially notice, such as claims supported by sworn testimony, either through an affidavit sworn true and complete, or testimony under oath of the witness, stand in open court, or deposition. Deposition would be any information that you leave in there, depositing, making a deposit of information, if you will. So number 5, recently some people in Nebraska allegedly avoiding having to go to prison for some time by posting at the last minute a single page bond. So they ended up bonding the case. The text of this bond, along with some explanations and comments accompanying this article. A presumption is defined as follows. A presumption is a deduction. Deduction means something that you get by subtracting. So to deduct information until you're left with the answer, and sometimes that's a good way to find information, to do some research, is by deduction. So a presumption is a deduction which the law expressly directs to be made from particular facts, and a presumption, unless declared by law to be conclusive, may be controverted by other evidence, direct or indirect, but unless controverted, the jury is bound to find according to the presumption. So they can just basically get off on charging somebody and getting away with sentencing them on a fucking presumption because it was never challenged. So then the jury is bound to find their presumption as facts. See how that shit goes? So the bottom line, the bottom line is that whenever we receive any kind of presentment, from a tax bill to a summons, complaint, indictment, etc., our proper course of action is to accept and return the offer for value served by a notary on our behalf. Discharge of the obligation occurs at the moment the offerer receives our communication. So one more time. Discharge of the obligation occurs at the moment the offerer receives our communication. It's already discharged. Contracts, and so that's why they're going to keep on sending you letters and shit like that to try to re-contract with you, hoping that you keep one of those. Contractual ratification has occurred through offer and acceptance. The circuitry closes on itself, the plus and the positive polarities discharge, and nothing remains upon which anyone can act upon. So when you understand the system like a energetic circuitry, electrical circuitry, then you see what it is and how the whole game is played, and how, you know, charge, discharge, and things like that. So that's when you're going to start to notice things like that. Alright, so a charging instrument. Presentment is an offer, an obligation created on the public side. By inventing a new borrowing against the creditor, the source of the credit, on the private side, your straw man is offered the opportunity to assume the obligation. What we must understand is that 1. Any presentment is a concocted debt on the public side created by the party responsible for issuing the presentment. Number 2, whenever you, i.e. a straw man, receives a presentment, through your acceptance and return for value of the presentment, you can perform a legal commercial jujitsu by diverting the force of the presentment back onto the issuer. So, number 3, the fabricated obligation constitutes a new borrowing, i.e. creation of more public debt, which they wish your straw man to assume, and which you, at the expense of your body and labor, must discharge. And, you know, it is a expense to you regardless of whether or not you look at the fact that you're not paying actual physical money. They're pretty much forcing you to go in there and either accept it or perform to some degree. And so that shouldn't be free either. I mean, you should know that, right? So even if you expect me to go in there and perform whatever, even if I agree to, I'm going in there, and there's going to be stipulated fees associated with that. I'm not just going to move my arm because you say so. You can pay me though, and I may think about it, right, and get it done faster for you. But that's how that's going to work. So keep that in mind. So whenever they give you an offer, you can counter offer that too as well. Okay, so any presentment can be discharged by providing the offerer with the charging instrument accepted in return for value, and utilizing your exemption as the source of credit for discharging the obligation. 5, a presentment is not an obligation that attaches to you unless you dishonor and do not discharge it. When you proceed correctly, and when you proceed correctly, the charging instrument constitutes funds that can be used to make you money. And that's what it is. So when you understand that debt is money, you can go ahead and keep that instrument because it does represent debt. You can go ahead and offset it, A4V accepted for value, and then go ahead and discount that and probably get some money on the private side. So if the offer does not honor your acceptance and return for value, then he is the one that's in dishonor and can be made the party obligated to pay you for costs, fees, and damages on the basis of dishonor. And I'm pretty sure that they know all about commercial dishonor and things like that too, because that's really the fundamental basis for how they operate. But they don't publicly say that, but that's really what it is. So they know all about that shit. So understanding the above scenario serves greatly to remove fear, false evidence appearing real from the equation, especially when we realize not only that the presentments can be neutralized, but that it can be turned into our advantage. And that's really what it is. They're really trying to hand you a check. If you look at it like that, that's really what it is. So the advantage, and it could really cost them because they might even have to actually fund it. You know what I'm saying? So the and they'll get tax bills from the IRS and shit like that too. Crazy. So get this shit audited. It's a bunch of different things you can do. So the advantages can occur not only by what might ensue from the offerer's dishonor of our acceptance and return for value, but by other means also. So long as one is ungrounded in his own existential spiritual position and ignorant of what the system is and how to deal with it effectively, fear is inevitable, and that's because you're looking at it wrong. So this is because the system is one of endless applications of legalized violence on the basis of fictions and frauds promulgated by other beings. None of these paper assaults, presentments in our creation or our property province concerning which we have authority to speak, they are all the truth and actions of the originator and therefore the originator's property and domain. Unless we understand what is happening, we are in the dark, having to deal with the things that can destroy us without possessing any liability to fathom and disarm them. The catch-22 of the system is that both traversing and joining the issues in any manner and ignoring, doing nothing, constitute a dishonor, guaranteeing our loss. And you see what it is, right? They're kind of putting you in a tough position. And that's why I have my contracts already to let them know how much it's going to cost them every time they try to dishonor a situation, or me personally, right? And how much it's going to run them. And you got to put them on notice. So the way out of this is you're damned if you do and you're damned if you don't. It's double bind is the comment of the paradox. And so, as much as they'd like to make you look like the asshole, I mean, they're really forcing it, And even if you're not operating commercially and shit like that, and you end up in a situation where they're trying to force it, it's like, it ends up becoming a fucking a clusterfuck of a situation, really, if you don't understand what it is that's actually going on. But I do think it's best to go ahead and to make contact with them prior to actually bumping into them just in the streets in general, which you will, because they're like fucking roaches. They're everywhere. So the problems are not solved on the level of problems. They are solved by operating from another domain or meta level, which in this case is our ground and the truth for which we have exclusive knowledge and authority to speak, and concerning which they have none. Now they must deal with our world, which they cannot address and cannot enter. And from that position, we require them to put up or shut up. Since they cannot substantiate the truth and validity in our domain, which is more powerful and fundamental than where they are operating, we can do so by turning the tables on them. Officials, attorneys, and banks do not want to honor this process for a number of reasons, largely because they have been making money from usurping and using our exemption, and do not wish either to be stopped from doing so or seeing us regain our sovereignty and autonomy by asserting our standing as creditor and using our exemption for our benefit and not theirs. So same shit they're doing to you as corporations, and they're raping and destroying, man. You can do the same thing. Okay, so standing and status. Whenever you receive a bill, citation, summons, complaint, indictment, etc., what you receive is an original issue presentment. It is also an assumption, a concoction contrived in the mind of the living being who dreamed it up. Since there is no bona fide assessment for the obligation, there is no commercial paperwork to support the contractual basis upon which the alleged obligation is based. Remember that the entire contractual basis upon which the alleged obligation is based. So remember that the entire colorable system functions by fictions and frauds. There is only presumption of assessments, i.e. color of assessment, since the presenter of their presentment did not attach anything of value to substantiate and support his position. And this is the thing. So he pretty much forgot to fund the note, right? So it's a note promised to pay, but there's nothing backing it. So he forgot to put value on it, and would like you to. So hence the for his benefit too, mind you, right? Some accepted for value documents. I did not find your check enclosed, and this is where that comes into play. So the document is grounded in the imaginary. Nevertheless, it can be traced to the author of the document and whatever strawman on behalf of which he acted to create this new debt currency. The presenter is giving you something created by inventing a debt and can be transformed into something of advantage to you if you treat it correctly. And that is true. You know, I always think it's funny how they just go ahead and create debt on the side of the road without being a financial institution. I wonder how that works. How they just creating money on the side of the road like that. Did they study banking? How does that work exactly? And how are you stuck paying the tax on the money that he created? So any genuine assessment involves a valid contract, bearing the authorized signatures of all involved parties, plus proof of breach of the contract by the one who is then rendered a debtor, plus an accounting of the sum certain amount owed based on a true bill that itemizes the particular dollar amounts owed for what specific things, such as goods and services received and not paid for, or specific performance promised and not performed, plus proof of the authority for those trying to collect from the debtor to operate as third-party debt collectors, plus a statement of commercial liability staked by every alleging party, anyone who makes any bookkeeping entry or acts in the matter. So the book, to back up his claims by indemnifying those harmed in case of his error, those acting in the system, such as attorneys, government officials, have none of these prerequisites. They have only assumptions which become actualized in our lives by making the assumptions real through our traversing or dishonoring. And so you're sitting there challenging, arguing with these people who have no authority or power or anything that can even physically touch you in your specific realm, but they would like to have you believe that they can, right? So, and if you believe that they can, then they can. So 12, the foundation of every record is on the commercial paperwork, consisting of two essential elements. One, a ledger of accounting consisting of an itemized list of goods and services provided by whom to whom, with corresponding monetary values indicated for each entry, backed by the contracts and records that substantiate the validity of each ledger entry. Number two, record of accountability identifying the party who takes commercial liability and responsibility for the accuracy, relevance, and verifiability of each bookkeeping entry. Although technically each document in commerce must be executed by and under affidavit of sworn true, correct, and complete, the commerce of this world consists of billions of people engaging in countless commercial transactions today. Obviously, it is impractical for the trillions of documents involved in an actual commerce to be done by taking each one to a notary to be certified and sworn as being true, correct, and complete. Commerce, to be practical, must be efficient, streamlined, and minimalist. The force and effect of every document, however, is ultimately its accuracy, relevance, and verifiability, combined with the sworn statement of some living sentient being that has taken the responsibility for the validity of the document and whatever information it contains. This must be so because every legal and commercial document involves someone paying and someone receiving gain. Since every such document involves a potential loss to somebody, accuracy and responsibility, accountability, liability must be inherent in all legal and commercial instruments. Therefore, although not in actuality sworn true, correct, and complete, all commercial documents may be enforced as if they were. And so this is the power that you get when you go into equity, because that shit is fucking incredible, to be honest with you. That's why I chose equity. You know, because there's a bunch of different, you know, I mean, there's a couple of different things you can do. You can either crawl under a rock or move into a cave, or understand that if you're going to be operating in commerce in any way, shape, or form, you're going to be coming into contact with these fucking people. So you might as well set yourself up, because it is a game of chess. You know what I mean? So when you accept and return an offer for value, it must be remembered that the value is that which is you, as the real living being, to giving life to the transaction. Only on the private side, such as you, your labor, and your private actual account, private treasury, UCC contract, trust account, which is your exemption as the creditor, from which the credit that creates the currency on the public side is derived, can have and give value. So, and they need you to act on behalf of that particular trust account, right? So the public side is imaginary, created in the mind, and possesses neither value nor substance, nor sovereignty nor life. Public entities such as corporations, trusts, partnerships, businesses, estates, and everyone's all caps name, etc., are persons which are legal entities, hence legis. They are not real beings. By being creatures of the state, persons have status, which is fiction and not legal, not standing, which pertains to real beings, and what is lawful, which is you, as the reality, are the substance and the source of all the public side. The source of all the things on the public side reflects uh, that from which it is derived, which is you. So any presentment you receive from the public side is a notice of the creation of the charge of the open account, which remains unneutralized unless you discharge it. You discharge the charge by performing a banker's acceptance that provides the asset credit that balances the liability debits across the accounting ledger. You want to use your exemption, which is inexhaustible, unlimited, for this purpose, in which case you can discharge any obligation. Anything that can be charged by creating debt against the credit can be discharged by performing an accounting offset by using the same credit. So when you accept an offer and return it for value in your real sovereign capacity as creditor, you have accord and satisfaction. The fact is your autograph. You, which I already showed you, I even did the numerology on that your autograph is the source. So you, or your signature. So you as the real being are the lawful man capable of bearing a bond. You possess rectus in curre, meaning right in court, and standing in judicio, meaning standing in law. That means that you are capable of bearing a note. Only a lawful man can do that. So the lawful man puts his autograph on the line, establishing the fact private men and women use autographs, self-generating marks. Public side employees use signatures, signs of their juristic persona. So to understand more of the money system operating in the world today, we must make a short digression into history. And so this thing goes a little bit into some of the, a little bit about Washington, D.C. and the Admiralty Maritime and how it all came into play when we went bankrupt in, what do you call it? June 5th, 1933, when they established the gold clause and things like that. That ended up basically launching the country into a commercial system, which was just basically a fiat currency system. They removed gold and silver from the system, essentially eliminating the possibility of any private transaction and things like that from any commercial entities. Mind you, it was only really ever taken away from the actual corporations. They don't have the power to tell the people they couldn't use it, but nobody knew that. There's a lot of shit like that, man, that, that's where you find the devil. The devil is in the details. That's why you got to take your time and look into the details. So set yourself up nice, get your contracts in place. It is a game of chess. Stop playing checkers with these clowns. That's what I got for you for now. Until we meet again.